Yeah. All right.
Okay. Good morning, everyone. This is Brian Pfeiffer of Deluxe Payroll. And first, I want to thank you for joining us today. We're really grateful for your time and looking forward to sharing how we can help you move forward and emerge from this COVID crisis. Obviously, never been a more truer statement than these are challenging times, right? And as businesses are playing roles that they've traditionally never had to play. So we really are excited to bring this opportunity to you. Unfortunate that the crisis created this, but a great opportunity for us to show you how we can help you. So with that, I'm gonna move it over to Kara, and Kara will take us through today regarding our topic.
All right, thank you. Hey everybody, it is good to be here with you. Today we will be talking about layoffs, furloughs, and recalls. How to manage those, how they look different, kind of what they mean in general for you in terms of compliance. So we'll take a look sort of at paperwork and, you know, checking the box for all of those. And then we will get into avoiding lawsuits and reducing your risk related to all of these things sort of towards the end. The audience is a good size today, so I will be able to take questions. If you want to send me questions using the Q&A box, not the chat box, but the Q&A box that's there somewhere on your screen with the Zoom webinar stuff, I will be happy to answer questions as we go. All right, so all that said, let's go ahead and get started. Oh, yeah, sorry. We will be sending you a copy of this presentation as well as a copy of the slide deck. So you don't need to take copious notes on this. You will have this as a reference in the future if you want it. And give us about 24 hours on that, give or take, but we will get that to you pretty darn promptly. All right, let's get started. So first off, we're going to talk about layoffs. And what's important to know about layoffs is that they're really just terminations. They're not sort of functionally different in any meaningful way. The one way they might be different is that it's easier to get unemployment because you just say, hey, I was laid off, and then the employer doesn't generally argue about that. But what a lot of employers don't realize is that even an employee who's laid off for cause, excuse me, not laid off, but terminated for cause, like poor performance, will generally get unemployment insurance. So at the end of the day, it's not really different than a termination, even with respect to unemployment insurance, because most of the time they're going to get it either way. All right, let's talk about final paychecks. So if you're laying somebody off, that's, again, just a termination. So we need to go through the usual final paycheck dance, if you will. Depending on what state you're in, there may be no dance at all, but a lot of states require that final paychecks come faster than regular paychecks. So if you lay somebody off, you may need to get them their final check within 72 hours. Or if you're in the state of California, you have to give them their final check on their way out the door. So check state law with that, and that is information we have available in the HR Support Center. We've got that all, you know, we have like basically a final paycheck section on every single state, so you can go check that out and see how fast you need to act. You'll also want to include PTO if that's required by your personal company policy or by state law. Some states require that PTO be paid out. They treat it like earned wages. So if you're in one of those states, again, that's on the support center, then you'll need to pay that out with that final check. You also want to make sure you're not taking any deductions that aren't allowed by law. This catches a lot of employers off guard they sort of assume fundamentally that if an employee doesn't return something like, a uniform or a laptop or some other piece of company equipment, that they're within their rights to take a deduction from that final paycheck. And that is often not the case. Usually you at least need the employee's written permission to do that. And then in a number of states, what you can take a deduction for is pretty limited. So you do want to check state law on that as well. Also, even if state law does allow your deduction and you've done the things you need to do, if that takes the employee below minimum wage or cuts into their overtime, excuse me, that would be a wage violation. So, even if they've agreed that you can take a deduction, if they don't return the laptop, and then they don't return the laptop, if taking that $500 out of their final check means they don't actually get minimum wage for the number of hours they worked, you violated the FLSA, the Fair Labor Standards Act, that's federal law, as well as quite possibly state law. So you want to be really careful with that one. When we lay an employee off, we need to notify them of their right to file for unemployment insurance. Technically, this may not be it's not yet a requirement in every single state. So some states required this pre-COVID-19. And then when the CARES Act passed, the government, the federal government said that states needed to notify employees of their rights to file. But states have been passing that on to employers, because how would a state, directly notify someone or even know that they'd been laid off or furloughed or anything else? So that buck is being passed to the state in some cases, but it's not going that fast. Those laws aren't being passed very rapidly. So my suggestion on this is, regardless of what your obligation may be, just go ahead and do it. Just give them notice of their right to file. If you go spend, 20 minutes or an hour, depending on how much is there, on your state's unemployment insurance website, you should run into information you need, such as any notice that you could download and give to them, or a link to that notice that you could provide. If you don't find anything on the state website, then I would just go ahead and tell them in writing, in their sort of letter or their departing employee paperwork, just let them know that they can file. I also think it's a great idea to provide additional information, FAQs, guides, anything created by the state unemployment insurance department that you can give them access to, just to make their experience a little bit less stressful. They're the one in this situation who's about to lose income and potentially not be able to pay rent, particularly if you're, sort of doing this in the near future. They're going to have a hard time finding a new job, unless they want to drive for Amazon. So this is a tough time for people. Even if they are going to get unemployment insurance, that doesn't make this a cakewalk. So if you can provide additional info, I think that's a really sort of, nice employer thing to do. You also need to provide a notice of their ability to continue their health insurance benefits if they have health insurance benefits. So if they don't have health insurance, then you don't need to do COBRA. But if they do have a group health plan with you, then COBRA will almost certainly apply. So federal COBRA applies if you have 20 or more employees, but almost every single state has something called mini COBRA. It'll look a lot like the federal law, but it kicks in at lower employee counts. So if you outsource COBRA, you need to notify the administrator of your plan within 30 days, and then they have 14 days to send the COBRA election notice. If you self-administer, you've got a full 44 days. But what I would suggest is that you not wait 30 days, assuming you don't self-administer, but tell your administrator ASAP. If you wait the full 30 days and they wait the full 14 days, your employee will probably lose coverage. And even though COBRA will be retroactive, it's a real pain to deal with that retroactivity. I've had friends, go through that period, and it's not great. So if you can tell your administrator, the day that they leave, that would help move things along, and once again, sort of be like, you know, the right, nice thing to do. So I definitely encourage that. I'd also suggest pointing them towards the health insurance and marketplace options that may be available for them. So employees may qualify for a special enrollment period. They definitely will, you know, when furloughed or laid off. But even if they elect COBRA, they may have the option of switching to a health insurance marketplace plan that's less expensive. They have 60 days to do that, or even after 60 days, if the price of your plan goes up significantly and they want to check out something else, they have the option to do so then as well. But if you can just give them like a link to the state marketplace page or the federal marketplace page, whichever applies, that would be awesome. They might find, you know, much more affordable options there. So once again, that's just sort of you like trying to help them out here. You're not required to do this. This is simply to be generous, to be kind. To that end, I would also suggest that you provide some other resources to employees who are on their way out the door. I've mentioned obviously state unemployment insurance department information, anything you can help them figure out there. You might want to link them to the governor's website or the state health department or CDC, any combination of those things. You know, if they're not particularly computer savvy, you can help them by sort of, you know, just providing a link to these things so they can sort of keep up with what's going on their own. Also, this is going to be a little bit demographic dependent, but you might want to provide links to local food banks or other charities that are helping out during these times, as well as renters resources. So a number of states and cities have suspended evictions or done other things to help people who can't make rent right now. And if you can locate those resources and direct your person that way, that would be great. Finally, you want to make sure you're complying with WARN if it applies. So WARN is the Worker Adjustment and Retraining Notification Act. It's a federal law that requires employers to provide 60 days notice if they're doing really big layoffs. So it only applies to you if you have 100 or more full-time equivalent employees. So that means we add up our part-time employees and our full-time employees, and we look at the equivalents at the end of all that adding. So it's possible if you have, you know, 300 part-time employees, that you actually do have 100 full-time equivalent employees. This doesn't apply to layoffs of less than 6 months, and it only applies if you're laying off, you're either closing an entire work site with 50 or more employees, or you're doing a layoff that affects at least 50 employees and 1/3 of your total workforce. So if you're a small employer, you can just sort of tune out this WARN requirement entirely. If you're not a small employer and you do think you're going to do a very large layoff, you should be checking out WARN. And we have more information on the HR Support Center about this. There is an exception for unforeseen business circumstances. If you laid a lot of people off at the very beginning of the pandemic, that exception probably applied. If you're now looking at doing a large layoff in the near future, it might not be an unforeseen business circumstance at this point. You'd want to make sure you feel comfortable defending that in court. And even if you did want to use that exception to the 60-day notice, you'd want to give as much notice as possible. Also, like with mini COBRA, there is mini WARN that applies at lower employee counts in certain states. So that's something you'll also want to check for. Mini WARN is not nearly as common as mini COBRA. Almost every single state has mini COBRA. Mini WARN is not nearly as prevalent, but it is something you should check for. All right, let's talk about furloughs now. So these are a lot like terminations, but also not a lot like terminations. There are a lot like terminations in a couple of really important ways for your employees. So we'll talk about that. First of all, though, what are the differences? So during a furlough, an employee is still on the books, right? We haven't removed them from payroll. We haven't gone through our usual termination processes. We're not going to pay out PTO because this isn't the end of employment. That said, if you are in a state that requires PTO payout, I would encourage you to either give the employee a recall date, an end of their furlough date, or make a note that it will end when some other condition is met, such as the stay-at-home order being lifted. So California in particular, they're always sort of my example because they have so many darn employment laws. They required payout even during a furlough if the furlough was for more than 2 weeks. That was pre-COVID-19. We talked to them directly a couple of times, the Department of Labor Standards Enforcement, and they have sort of changed their tune a little bit on that. And so their requirement is that you provide that recall date or the end of the stay-at-home order as a condition. And I think that's a great idea to use in any state, or probably even if you're a company that says you pay out PTO at termination, but you don't want to do so right now because it's not a termination, it's a furlough. I'm sorry, somebody asked what's PTO. I'm really used to that term being thrown around. That's paid time off. So it could be vacation, it could be personal days, it could be paid time off. People call this a number of things, but PTO is just shorthand for any kind of paid time off that's being used by employees. So we also don't need to do that final paycheck dance that I mentioned because it's not a final paycheck, right? It's just the last paycheck for a little while. So they can stay on your regular payroll schedule. You don't need to do anything fancy to get them that last bit of money before they're going on furlough. So the similarities are sort of larger in terms of impact on your employee who's being furloughed. One of those similarities is that they will be eligible to apply for unemployment insurance, which is a good thing. We can still keep them on the books and they can still get UI. So I'm going to call unemployment insurance UI probably for the rest of this presentation if I haven't done so already. So that's what that abbreviation is. There are a couple ways they could qualify for UI, just the general, like I'm furloughed way. If you've reduced their hours, they could get partial unemployment. There's also something called work share that you'll probably want to look into at the state level, but they will be able to get paid. So not the end of the world for them. You know, UI is always a little bit difficult, and some states are having a much harder time with their systems right now than others. But there is sort of a light at the end of the tunnel if you have to furlough people for a while. They will also quite possibly lose health insurance coverage, but there may be some alternatives to losing coverage right now. So generally, plans say something like, you know, employees need to be regularly scheduled to work 30 hours or more per week. That's probably the most common plan provision. They can certainly be different. Someone suggested the other day that plans for smaller employers tend to have a lower number of hours required. I wasn't aware of that. That might have just been their personal plan. But anyway, you need to read your plan provisions and see what they say. So if you furloughed someone, either by reducing their hours significantly, maybe to 15 hours a week, or by you know, sending them home entirely for 2 weeks or 6 weeks, they'll probably lose coverage according to your, you know, basic plan language. And we do need to administer our plans according to their terms. We don't want to be committing insurance fraud, you know, by saying that people are working when they're not. That said, some flexibility is being created because of the crisis. So it's possible that your carrier, out of the goodness of their heart, is letting employers change their requirements. It's also possible that the state you're in is requiring carriers to allow employers to change those requirements. So if you are furloughing people for a little while and you'd like to continue their health benefits, just because, you know, that's a nice thing to do, and it's a pain to get people on and off. You know, you don't want them to have to use COBRA. Do check with your carrier because it's possible that there's going to be an exception to the usual rule right now. Also, if you're using the ACA Lookback method, your people may remain covered even during a furlough. So this is for applicable large employers, meaning those with 50 or more employees who have to require health insurance or pay a penalty, you know, play or pay as it's sometimes called. So if that applies to you and you're using a look-back measurement method to figure out eligibility for group medical coverage, then you might have some people who maintain their coverage during what's called a stability period. If none of this is ringing any bells for you, don't worry about it. But if you are an applicable large employer, you could look into this. If none of those potential continuation scenarios apply, then we're back where we started with a regular old layoff or termination. The person's going to lose coverage, and we need to give them COBRA notice or mini COBRA notice, or, you know, contact our administrator to do that for us. With respect to unemployment insurance, we sort of have the same obligations. I would suggest that you make sure they know that they can file. I'm sure they'll be asking you about this on their way out the door as well. And then for furloughs in particular, you want to see if you have any special obligations. So in Georgia, for instance, you have to file on behalf of a furloughed employee, which is crazy. That sounds like a California law, not a Georgia law. As far as I know, as far as anybody I work with knows, Georgia is the only state that requires that right now, but you might have some other obligations. So chances are, if you furlough a bunch of people, you will get a letter from the state that, you know, gives you further instructions, such as when you call these people back, let us know, or if you call them back and they don't accept the work, let us know. So just keep an eye out, make sure you're reading the paperwork that's sent to you by the state. And really, I'll come back to my suggestion from a little bit earlier, which is I think you should spend some time on your state unemployment insurance department website. Some are better than others, but most probably have some guidance that will help you understand sort of the picture, the big picture right now. And I also mentioned earlier partial unemployment and work share programs. Partial unemployment is generally available when somebody has less than 40 hours of work a week, and they usually have 40 hours of work a week, so you know you've cut their hours significantly. That was already available in possibly every state, or certainly almost every state. Workshare is a little bit different, and that is becoming more common also because of the CARES Act. When we passed this big federal unemployment insurance benefit thing, the requirements for states changed if they wanted to get in on the federal benefit. So workshare is something you may want to learn about as well. For the most part, you know, it's on the employee to figure this stuff out and to file in a way that makes sense for them. But certainly as an employer, you're going to feel some benefit by understanding these terms. You've seen this slide before. I would encourage you to provide furloughed employees with the same sort of additional resources as employees you've laid off. But I did add a couple of bullets on the slide. So the first is, it's actually the second to last bullet, it's the first new bullet, is that I think you should tell employees about your Employee Assistance Program, or your EAP, if you have one. So an EAP is a program that gives employees resources like financial counseling, you know, 4 to 6 therapy sessions, you know, support groups for divorce or loss. It's got a lot of sort of options to connect employees with benefits at a free or discounted rate that might be really helpful to them right now. Sometimes EAPs are bundled with health insurance, so if they lose their health insurance, they'll lose access to the EAP, but sometimes they're not. I've also been told that sometimes EAPs don't actually check to make sure somebody's still eligible. So it's possible that if they just call the phone number, they'll get help regardless. That's a really inexpensive benefit as well. So if it's something you haven't looked into before, it might be worth checking out. It's between like 75 cents and usually $2 or $3 per employee per month. So pretty cheap if it's something you think would be beneficial to your employee group. And then finally on this page, I would suggest providing contact information for HR and payroll people who can answer additional questions for your people who have been furloughed. So I know where I work, surely there is some phone sheet that has everybody's phone number, but I don't know where to find it. It would take considerable digging on my part to find an actual phone number for our HR people. Also, since we're mostly using life size to communicate via video conferencing these days, you know, I don't know that the old phone numbers are even accurate anymore. Anyhow, my point here is when you're letting people head out on a furlough, make sure you like give them by hand the contact information that could be relevant for them, because digging it up later might be a lot harder than you think. And then finally, when you're letting people go off on a furlough, I shouldn't say letting, when you're requiring people to go off on a furlough, keeping in touch is really important. So if you've ever had an employee go on an extended FMLA or ADA leave, and you weren't quite sure how long it was going to be, and you asked them, you know, hey, keep in touch, or when do you think you'll be back? And they gave you like a vague date, and then you didn't hear from them, you probably started to wonder if you still had an employee anymore. And employees on furlough are going to have the same feelings if you're not talking to them at all. So I would recommend communicating weekly. I have a colleague who thought that was total overkill. That sounded like a lot of work to her, but I think weekly is best. And you can probably find a way to do this that's relatively low effort. If you've got a company intranet, you know, a place where employees can go see things that the outside world cannot, that's a great place to just sort of put a weekly bulletin. Doesn't have to be a lot of details. It doesn't have to be super inspirational. Just let people know, you know, hey, we're still planning to reopen when the order is lifted, or, you know, many orders are being lifted right now. So maybe the message would be, you know, we are going to start bringing people back really slowly. You know, week by week, we're assessing. We'll let you know. Even if you know very little, any kind of communication will be helpful and will make them feel better. You could also send this as, you know, a text blast or an email to the whole company. If you're going to do that, though, again, you want to make sure that you've got good contact information for the employee. Not only should they have good contact info for you, but you want to make sure you've got good info for them. You know, it's possible that when they started working for you years ago, you know, they had a different phone number. They had a different address. They gave you an email account that was a burner email at the time, and now they don't even know how to log into it anymore. So make sure you have an appropriate way to contact employees once you let them go. All right, let's talk about recalling employees now. This part tends to be at least a little bit more fun. First, we'll talk a little bit about paperwork. So if we're rehiring someone after a layoff, meaning we actually let them go, there was a termination, we called it a layoff, but it was a termination. We separated employment completely, we took them off the payroll, we gave them a final check, etc. Then we're pretty much going to treat them like a brand new employee because they are a brand new employee. So we want to do an offer letter. We will enroll them in benefits the usual way. We'll report to the state that we have a new employee. And you know, whatever else is required at the state level for you to hire a new employee, we're going to go through those steps. They should fill out a new W-4. So even if they weren't laid off for very long, there's a new W-4 this year. It's more complicated. I think people don't really like it, but it is required. So don't use their old W-4. If you laid them off in 2020 and then brought them back in 2020, they need to do the new version. You should also do a new I-9 unless, of course, they were only hired 3 years or less from the time you're bringing them back. So a new 9-9 isn't necessary if they're rehired within 3 years of completing the original. So if you hired them 2 years ago, you're bringing them back tomorrow, the old I-9 is fine. If they were hired 5 years ago, you need to do a new I-9. If you're using their old I-9s, it's not 3 years old yet, do fill out Section 3 for rehires, though. What about recalling people from a furlough? Well, we don't need a new W-4 or a new I-9 because they were never gone, right? They've been on payroll this whole time. They're still an employee. That said, I do think you should provide an offer letter when you bring them back. This will be important for a few reasons. So first of all, if anything has changed about their position, pay, reporting structure, or responsibilities, you'd want to put that in the offer letter. So they could basically decline it and say, I don't want to come back under these new circumstances. You'll also want to list the steps that you're taking and any policies you're implementing to keep the workplace safe. A lot of people don't really feel comfortable coming back to work yet, but if we need them to come back, then we need them to come back. So how can we make them more comfortable? Well, tell them what you are doing in the workplace to make it safer. Also, if you are going to implement certain policies, giving them a heads up so they can sort of mentally prepare for what they might have to do can be helpful. Just making it less jarring when they return will be appreciated. So if you're going to totally redo the floor plan to create extra separation, if you're going to require that they wear masks, if you are going to, reduce customer flow significantly, any of this information can be really helpful to them. And then maybe the most important thing on the offer letter is asking them to confirm or deny whether they're coming back and providing a deadline for that response. So we have created a recall from furlough letter for you. It's in the HR Support Center. We've done the heavy lifting. If you need this document, it's there. It just has some fill in the blanks. And what you'll see for this, third section, this third bullet here on that letter is literally a checkbox. It says, yes, I'm coming back. Another checkbox that says, no, I'm resigning. And then a sentence that says, if we don't get this back from you by X date, you can fill in that blank with whatever you want, we will assume that you're voluntarily resigning and go through with termination procedures. This is just going to make it so much cleaner if you get into a debate with them about whether or not they really quit, or if you have to, prove to the unemployment insurance department that they were offered their job back and you didn't hear from them. All that is just going to be much simpler if we have some documentation. And that document has been created in a way that people don't need to print it. They can just sort of like fill it out online, or not online, but in Word, and send it back to you. Or they can print it and use a pen, that's fine too. But we try to make that so it could be sent electronically. Somebody just chatted in a question about benefits coverage for people who are returning. So good timing. You should be able to restore employees' benefits on the first of the next month when you bring them back from a furlough without a waiting period. And yeah, I would encourage you to do that. There's not really any reason to make them wait. Obviously, I suppose you could save a little money, but under the circumstances, and then to sort of be a good guy employer, I don't know why you'd make them wait. So yeah, by all means, you should be able to enroll them at the first of the next month and not do your usual 60-day waiting period or whatever it may have been. You can't generally enroll anybody mid-month. That's just not how enrollment works, but they shouldn't have to wait too long. The very first question somebody chatted in today was about employees who don't want to come back. And this is perhaps the most common question we're getting right now from every direction. So depending on an employee's reason for not returning, they may or may not qualify for continued unemployment insurance benefits, which is generally what employers want to know. Will they keep getting UI, if they decline to come back to work? And the answer is probably not, but maybe. So if they're high risk, for instance, let's say they're pregnant, and you can't accommodate them sufficiently right now, you can't make them feel safe in the workplace, then they will probably continue to get unemployment insurance, because they can explain that to the UI department and say, look, I'm high risk, you know, my job is retail, they couldn't find anything other than, you know, high contact with customers for me to do, and I can't work from home. That person will probably keep getting UI. Also, if they have kids to care for and their schools are closed because of COVID-19, or they're caring for people who are sick or quarantining because of COVID-19, or they themselves are sick right now with COVID-19, those are all going to be acceptable reasons to decline recall, and they'll continue to get benefits. I've got a little asterisk there, though, because there are FFCRA leaves. FFCRA is the Families First Coronavirus Response Act, and it created the first ever paid government sick leave, or government-funded sick leave. So if an employee is sick with COVID-19, taking care of someone, taking care of a child, they will be eligible for FFCRA leaves, which are either partial or total income replacement, depending on the situation. And you pay that out, and then the government lets you take it off the top of your payroll taxes. So if you haven't heard of this yet, this is definitely something you'll want to look into, because it's going to be really relevant, at least for the rest of the year. If you bring people back and they need an FFCRA leave, then so be it. And if you need to bring people back to comply with the Paycheck Protection Program, then you'll bring them back. And if they need a leave, you can put them on FFCRA leave. It gets a little bit complicated. If you have HR on demand, we can certainly talk through, you know, each scenario with you. But let's walk away from the FFCRA leaves for a minute, come back to the other reasons an employee might get unemployment insurance if they decline your recall. The last one of those is if you're not offering a workplace that meets safety guidelines. So for instance, if your state requires that restaurant workers wear masks, and you want to buck that trend and say, we're not going to wear masks because we're not afraid, and it's too hard to talk through a mask and breathe through a mask. So, you know, we're not going to let employees do that. Really, actually, even regardless of what your state says, if you're forbidding employees from wearing personal protective equipment like a mask, I think that they'll probably continue to get UI, because it probably won't be considered a reasonable request given the safety considerations. If you don't think an employee has a good reason to turn down your recall, you can report them to the state. And you might be required to report them to state even if they do have a good reason to decline your recall, and then the state figures it out. So some states are actually setting up like reporting systems right now for this reason, because unemployment insurance, because of that $600 bonus, is better than it's ever been. So yeah, there are people, particularly when, you know, the workplace is scary, there are people who would rather stay home, and they might be making more on UI than they make in the workplace. So I get it, that can be compelling. So states are setting up ways to basically report people who are, you know, declining a recall in favor of hanging out on unemployment insurance, because that is not the point. That's definitely not the point, and we don't really want to encourage that. All right, let's talk now about avoiding lawsuits and important selection criteria. Whether you are laying people off, furloughing people, or recalling people, you should have a good explanation for why you've selected the people you have for any of those employment actions. If you have furloughed everyone, you know, because your state closed all non-essential businesses and you were non-essential and people can't work from home, and so, you know, aside from the owner and one HR person, you literally furloughed the entire company, then don't worry about this. But assuming you furloughed some portion of people but not all of them, or, you know, you're only going to recall half of the department because business is slower, then this documentation and having non-discriminatory selection criteria is going to be really important. So first things first, you're going to want to think about your business needs, either now or in the future. Maybe you're laying people off right now, or maybe you're about to bring people back. So think about what kind of staffing you need to operate at the level that meets with current demand. So underestimate how many people you need to bring back. If you've got people on furlough and you bring them back and they stop their unemployment insurance claim, you know, and they work for a week, and then you send them home again because you realize you totally overestimated how many workers you needed, their claim will have stopped and they'll have to restart it, and that's a real pain and will interfere with their income for at least a few weeks, most likely. So try not to bring people back until you're pretty darn sure that you actually need them. If you lived through 2008 to 2010 as a business, you might have a good idea of what a downturn in the economy is going to do to you. So that might help with your business planning. Think about skill sets that you might need to adapt to future, you know, business requirements. If you're a bakery, for instance, you probably aren't going to cater a lot of large events, you know, this summer, but you might have, you know, significantly higher demand for delivery of cakes and whatnot, whatever it is you bake or you make. So, you know, consider how things are looking different for you in the future and how that impacts your staffing needs. Once you've got that sort of big picture, then you can get down to job-related criteria and thinking about employees individually. So you'll want to have some criteria that are job-related that you can be consistent with across the board. So consider unique or difficult to replace skill sets. If you are, again, a bakery and you've got, you know, one person who is the best decorator, you know, in your state, then let's make sure we're getting that person back ASAP, because they're going to be really hard to replace and they may be in high demand. Overall performance is, of course, a good metric. If you've got performance reviews, that can be pretty darn easy to figure out. Seniority is a really easy one that's low risk, but it might not be in your best interest to rely on seniority, certainly not only seniority, when you're trying to operate lean, because that might not reflect overall performance or unique skill sets. And then a final idea, you can of course go outside these 4 bullets. These are just 4 things to consider. The final one would be demonstrated ability and willingness to do work outside of their usual assignments. So we need team players when we're trying to operate lean. Let's say you are a small law office. You know, you've got a couple of paralegals and a receptionist. You want to bring everybody back, but you are pretty sure the receptionist is going to need to take intermittent leave to care for a child. Well, are those paralegals willing to sit at the front desk when the receptionist is gone? You know, consider whether their attitudes work for you. I guess I should have made this scenario that you want to bring back half of the paralegals. So decide which paralegals, or think about which paralegals are going to be willing to sit at the front desk and answer the phone and do something that's outside of their regular job description. And that might be something you want to consider going forward. If you don't have really good documentation, you can certainly create it now. You know, if you don't have much, if you haven't done performance reviews, but you know who your good performers are versus your poor performers, now is the time to create that documentation. But you also might have some documentation that you're not thinking about. So like if you've got somebody who's chronically late and you don't write them up because you're not that great at managing in that way, it's still possible that your login system or your timesheet, you know, records have that history of tardiness. Also, if you've got salespeople, even if you're not making notes in their personnel file about, you know, whether they're meeting or exceeding expectations, you've got their pay stubs that show how much commission they were making, so you can compare them to others. And then finally, these last couple would certainly require some digging, but, you know, you may have evidence in conversations with people about whether they've been good or bad at following up on requests, or whether they've been successful when they have, completed projects. So you could go looking for that as well. In a lot of cases, we're going to be relying on our managers to help us pick people for layoffs, furloughs, or recalls. And if you're the sort of ultimate authority with respect to who comes or goes, you should be double checking your manager's reasoning for their selections. So often we get a phone call saying, we have an employee with performance issues and, we want to let her go. She just told us she's pregnant. Is that a problem? And we say, do you have any record of the performance issues? Is there any documentation of that? And they say, oh, no, we don't have any documentation of the performance issues. Well, that's probably actually based on a bad reason. They probably want to get rid of that employee because she's pregnant. They know she'll need leave. They think it's going to be a pain in the ass, to accommodate her in the future. So, they've decided to cover it up with a record of poor performance. These are things you want to be looking out for as, the ultimate authority on who comes and goes. These are the things that will get you into a lawsuit. So check for those. If your managers don't have great documentation, if you've never heard about these performance issues before, this is definitely something you want to dig into. We obviously don't want to consider any protected classes or protected characteristics. That seems really obvious. I probably don't even need to say that. But I do think there are a couple ways that we will find ourselves in trouble with COVID-19 in particular, often when we're trying to do the right thing. So with age in particular, there's sort of a sneak attack via something called disparate impact. So hang with me here for a second. This is a very legal concept. But basically, disparate impact happens when you do something that seems logical and has a good business reason, but it has a disparate impact or disproportionate impact on a certain protected class. So for instance, if you cut your high earners, because that's the easiest way to reduce payroll costs, there's a decent chance that's going to impact your older workers more than anyone else. That may still be an acceptable, criteria to use, but you probably want to talk to a lawyer first because that's something you may have to defend in court. I don't know that most employers are actually planning to just cut high earners, but I know it's a thing that happens sometimes, so I wanted to put it out there. Also, with respect to age and disability, employers may think that they're doing employees a favor, either by laying them off or furloughing them or recalling them last, because people over 60 are at higher risk and people with certain conditions are higher risk. So that may well factor in to what you do at the end of the day, but it shouldn't be part of your first level of analysis. It's not your job to make health decisions for those employees. If they want to come in and they're not concerned about the higher risk, let's say you've got a perfectly healthy 65-year-old employee who has, a really good mask and they want to do their job, they're going crazy at home. You would not want to say to them, no, I'm going to bring you back last because you're older and you're high risk and I'm afraid of a workers' comp claim. You wouldn't want to go that direction. That would be really clear discrimination. That said, if you, offer jobs back to a number of people and some of them respond and say, hey, I'm high risk, I'm older, I'm pregnant, I have diabetes, I'm afraid to come back, then you certainly can grant that individual a reasonable accommodation, and you should. So the ADA, the Americans with Disabilities Act, applies to you if you have 15 or more employees, and it's going to require that you go through what's called the interactive process with an employee who needs an accommodation to do their work or to continue working in the future. So things we might see with respect to COVID-19 and reasonable accommodations would be recalling someone last or giving them an unpaid leave. Maybe, you want to bring them back, you want them to be on the books and with you and available occasionally, or, you know, you want to make sure they're available in the future. So what they need right now is really just an unpaid leave. Allowing people to work from home is going to be easy pickings in terms of reasonable accommodations, as well as wearing additional PPE. So like I said, I would not prevent any employee from wearing PPE, whether they're high risk or not. But if someone wants to also wear goggles, let's say, or gloves, you know, the fact that you think they look a little bit ridiculous doesn't make it an unreasonable accommodation. So we definitely want to be considering things like that under the circumstances. And my final note here is that compassion is legal. So if an employee has a good reason to either come back first or come back last, you should definitely consider it. Discrimination is really only a problem if it's motivated by someone's inclusion in a protected class and leads to adverse employment action, meaning something bad happens. Employers can get really wound up thinking that treating anybody differently for any reason under any circumstance is going to get them in trouble, and that's really not the case. Discrimination and harassment both have very specific legal meanings, and they are based on inclusion in a protected class. So if we don't have a protected class at play, if that's not, you know, factoring in, then we can make different choices for different employees. So for instance, if someone has a wife at home who's immunocompromised, she's undergoing chemotherapy, and therefore he requests to be called back from furlough last, that is reasonable and definitely something we can consider. We want to be compassionate throughout this. We want to, you know, see the human, acknowledge the human in each of our employees. All right, I wanted to point out a couple of resources we have available in the HR Support Center before taking any other questions you guys might have. So if anybody has questions, chat them in now, and I will come back to them in just a few minutes. But let me show you a couple of resources we have. So if you go to the HR Support Center, we have something called a Return to Work checklist. I can talk. And this just sort of walks you through a lot of things to think about when bringing employees back. There's a lot going on out there. There is a lot to think about. So we're hoping that this in particular will help you get your feet under you with respect to reopening business and bringing back the bulk of your employees. Another item we have is this quick start guide on deciding who to recall from furlough or layoff. I actually wrote this, and it covers a lot of the stuff that we just talked about in the last 10 or 15 minutes, except in, you know, a little bit more detail. So this is something we have available. But we have lots and lots of other resources as well. We've got, you know, updates on state sick leaves that have changed. We've got lots of information on the FFCRA I talked about. We've done probably at least a dozen 2-minute HR training videos on COVID topics. So those are just little tiny PowerPoints, kind of like what you just watched, except 3 minutes or less in most cases, that will walk you through a specific thing related to COVID-19. And we actually have those on all sorts of other regular employment topics as well. So we've got lots of stuff there for you. All right, let me come back to some Q&A here. We've got a couple of questions. Someone asked if we're required to bring employees back for forgiveness process of the payroll protection. I keep saying payroll, but it's paycheck protection program. So yeah, if you're doing PPP, you do need to bring people back, but I have not dug into that. So yeah, if you have a PPP loan, basically read those loan terms really carefully. You definitely, I know you need to bring back most, if not all, of your employees. I think you need to spend 70% of the money on payroll. Don't quote me on this. I'm really not an expert on that loan. But yeah, that's definitely going to interact with your decisions to furlough or recall or lay people off. And in most chances, it's probably going to lead you to recall people, even if you don't have work for some of them right now. Someone asked me to address the over 40 years old thing. So the Age Discrimination in Employment Act, the ADEA, is a federal law that applies to employers with 20 or more employees. And it says that discriminating against anyone for being 40 or older is illegal. So, you know, when we say you can't discriminate based on race, that doesn't just mean that we're protecting people of color. It means white people are protected as well, right? Any race is protected. The ADEA is interesting because it does not protect people under 40. So if you want to discriminate against someone for being 20 instead of 30, you could technically do that and the ADEA wouldn't care. ADEA wouldn't care. But as soon as they hit 40 or older, we need to not base employment decisions on age. So that would also apply if you've got people who are over 60 or over 70 working for you and you're concerned about their health, you know, in the light of the pandemic. So we wouldn't want to, again, be making those decisions for them. If that older person asks us for an accommodation, if they ask to be recalled last, we can certainly accommodate that, but we wouldn't want to decide to lay off or furlough, you know, everybody over 60. Or really anybody, if we start making that decision about anybody over 40, we have violated the ADEA. So that's something to keep an eye on. All right, there was one question about school closures. So somebody said, on the closed school scenario, we're about to be in, you know, it's about to be summer where schools would be out anyway. How is that being handled during summer months? So this is a little bit off topic, but I have a whole webinar on the FFCRA as well. So I'm happy to get into that. If the child care provider that someone would usually use during the summer is closed because of COVID-19, then expanded or emergency family medical leave, EFMLA, which is this brand new thing created by the FFCRA, that will kick in. If the child was, let's say, 13 years old, and there were no plans for summer childcare because this kid can entertain himself, right? He's going to be at the mall, he's going to be on a scooter, he's going to be on his video games. He didn't have childcare that's now closed. Then the EFMLA will not apply. So there has to have been a childcare provider that is closed because of COVID-19. So, you know, a lot of states are reopening. The childcare providers are also reopening, although some of them are doing so on pretty staggered, limited schedules. So even if someone's childcare provider was open, if they couldn't get them in because of COVID-19, emergency FMLA would apply. But it's going to be a case-by-case scenario. This isn't, you know, carte blanche for everyone in the world to say, oh, I'm going to take summer vacation with my kid. If that kid didn't have a child care provider that's closed, then no leave kicks in. However, if someone usually would have their, you know, 3-year-old and their 5-year-old in daycare throughout the summer, and that daycare is still closed, then that FFCRA leave will once again kick in. All right, thank you all so much for joining me. I'm going to kick it over to Brian for just a minute here to close us out.
Always helps if you take it off mute, right? So,
It does.
Kara, thanks so much. Obviously, the questions, good interaction today during the session, and clearly a sign that this is really a timely topic, and really spot on. So we know, everyone out there, again, thank you so much for joining us. We know these are really complicated times, and having access to the true professionals like Kara, we know is going to be important to you, right? To provide the right guidance and insight that you're going to need as you start to emerge from the COVID crisis. So we get it, right? It's things are becoming far more complex every day, and at times I'm sure you feel a little overwhelmed. So we want to make sure that we can provide the right guidance and insight to you, and keep you out of any bad situations from that perspective. So thanks again for joining us today. And if you have an interest, as it shows right here on the screen, please contact your sales representative, customer service rep, and you can always find us at deluxe.com/payroll. And we love to have an opportunity to chat with you about this service and others. So thank you so much, and I hope everyone has a great day.